Good morning, ma'am. Are you Glenda Williford?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Give me just a second to get that pulled up.
Our agreement, Your Honor, is for her to go into special needs safety.
Thank you. Sorry, it's taking a minute for my computer to get pulled up here.
Your Honor.
Okay, so Ms. Williford, in cause number 24, DCCR 1720, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 3rd of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 5-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that...
Judge, we've agreed to go counts 3, 4, 7, and 8.
Thank you. 3, 4, 7, 8. Count 3 alleges that you provided a urine sample August 14th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes.
True or not true? Count 4 alleges that you provided a urine sample September 18th of 2025 that also tested positive for tetrahydrocannabinol. Is that true or not true? Count 7 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true?
Sure.
And then count 8 alleges that you are behind in your court-assessed fees as of September 18th, 2025 in the amount of $688. And is that true or not true? Did you enter your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand, if I follow this agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Speak up, please.
Yes, ma'am.
And it looks like the agreement that you've reached is to remain on probation, but enter and successfully complete the special needs safety program. Is that your understanding?
Yes, ma'am.
And we've got probation here with us today, and is that the recommendation from probation as well?
Yes, ma'am.
Okay. I am inclined, if I follow this agreement, to extend the probation by some amount of time, just based on the allegations and the time that'll be spent there. So I want to make sure there's plenty of time after that she has still on probation. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Williford is not competent?
There you go.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. Looks like there's some, everybody's willing to work with you, but I want to make sure you understand that we're going to send you to the special needs safety program as a condition of your probation. I'm going to extend your probation by 1 year, and this is going to be, hopefully, listen carefully to what I'm saying, okay? Because this is the second chance you're being given, and there will not be a third. So you need to take advantage of every opportunity that is being given to you. You're going to get help with drug abuse. You're going to get help with mental health, with everything you need to be successful when you get out of safety. If at that point you don't follow through and do what you're supposed to do, you're going to be back in here and you're going to be looking at going to prison for up to 20 years. You understand? You okay? Are you okay?
This is a critical emotional pivot in the courtroom. The defendant is trying to explain the why behind the violation, but here's the harsh, legal reality. Courts focus more on compliance than justification. Even if there's a medical reason, probation conditions don't bend unless they're officially modified. And right now, the judge is watching not just what's being said, but how it's being said. Interview 1.
You're getting white. She's getting white.
I had a statement prepared for you, explaining the only reason I was doing marijuana at the time was because of my cancer, my pain management for cancer. And I will promise you on Jesus' happy golden It's all that I'll never touch the shit again if you let me go home.
Are you seriously gonna stand here and talk
No.
like that?
No, ma'am, I didn't mean to. I'm terrified. I'm so sorry, ma'am. I just didn't realize how much trouble I would get into.
You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
And just like that, the tone completely shifts. What was almost a second chance starts hanging by a thread, not because of new charges, but because of attitude and courtroom behavior. Judges take respect seriously, especially when they're offering leniency. One wrong word, one wrong tone, and that opportunity can disappear instantly.
Yes, ma'am. I realize that. I was trying to...
There's all kinds of other ways to deal with issues. And there's definitely more respectful ways to speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now.
I'm so sorry.
Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Go back with the bailiff.